We're going to go ahead and get started. I hope everyone was able to enjoy some lunch beforehand. The taco bar will be set up throughout the duration of the program. So if you'd like more to drink, more to eat, please help yourself. My name is Sabra. I am the Director of Training Programs and Strategic Business Development for the law school. And as part of my portfolio, I oversee the Master in the Study of Law, our Government Contracting and Procurement Masters and Certificate program here at the law school. And I am pleased today to be co-hosting this workshop with Thompson Hine. This is the second in our workshop series focused on government contracting. And we look forward to having our presenters talk to us a little bit today about navigating litigation and investigations for government contractors. If you have any questions about our Master in the Study of Law and Government Contracting and Procurement, please reach out to me. It is a 100% online master's program. No entrance examinations are required. Bachelor's degree is the only requirement, and it is 30 credit hours, and you can complete it in as little as 1 year. If you would desire to do so, that would be very aggressive. Most students take 3 to 4 years to complete that program. We also have a certificate option, which is a 12 credit hour option. And the same courses that are offered in our Master in the Study of Law Government Contracting program are the same that we offer in our certificate program. So that may be of interest to those who don't want to go the full-blown master's route, but are looking to develop a little bit more knowledge in government contracting and procurement. Again, if you have any questions, please feel free to reach out at any time. And again, welcome, and without further ado, Dr. Markin.
Thanks a lot, Sabra. Let me advance a couple of slides here. I'm Jamar King. I'm a partner at Thompson Hine. I sit in our Dayton office. For those of you in the room, we are down at Austin Landing, about 12 miles from here. I am in our business litigation and government contract practice groups. I've represented companies in a wide range of industries at all stages of litigation, but I have a particular focus on representing businesses and government procurement. I provide litigation support. I've helped manage responses to subpoenas and CIDs, and generally help government contractors if they need assistance walking through investigations. Today, I am joined by my partner from our Washington, D.C. office, Ryan Spiegel, and an associate from our Cincinnati office, Ben Sandlin. Ryan's focuses his practice on regulatory compliance, guidance, business counseling, and dispute resolution for clients operating in the complex realm of government procurement. He often advises contractors on negotiating agreements, responding to government investigations, organizing their corporate structure, and obtaining set-aside statuses for small and disadvantaged businesses. Ryan has a deep experience with contract law, government procurement, trademark law, and corporate law. That experience affords him the keen insight needed to address potential issues and concerns for both creative solutions for government contractors. In addition to his work as an attorney in our firm, Ryan is currently a member of the Maryland House of Representatives.
House of Delegates.
House of Delegates. He is a member of the Maryland House of Delegates. Ben is a litigator and trial lawyer from our Cincinnati office. He focuses on government enforcement, white-collar and criminal defense, complex regulatory matters, and state and federal law. His practice includes experience responding to grand jury subpoenas, civil investigative demands, conferring with government investigators, managing issues related to search warrants, representing clients in pre-indictment investigations, preparing clients for trial sessions, and drafting all types of motions. In his spare time, Ryan is a coach for the mock trial team down at the University of Miami. And we are going to talk to you about a few topics here. The agenda is, to get started, is a general refresher on the FAR and primary acquisition methods, considerations for bid protests, best practices for avoiding disputes with partners, managing claims under the Contract Disputes Act, responding to information requests, and we're going to talk to you about avoiding liability for procurement fraud. Before we get started today, I have a few housekeeping notes. First, today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. This presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions being expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members' clients, employers, affiliates, Thompson, Hine, or the University of Dayton. The content should not be taken as advice, as the views expressed are for informational purposes only. For those attending virtually, if you have any questions during the webinar, please feel free to use the question box located in the control panel on the right side of your screen. We will do our best to answer any questions posted in that question box. We will be offering CLE credits today for today's webinar. For those attending virtually, be sure to complete the verification of attendance survey. A link to the survey is included in the agenda that can be found in the handout section of the control panel on the right side of your screen. We will also paste the link in the chat at the end of the program. The tracking codes will be announced during the middle of the program and at the end of the program. For those of you attending in person, please make sure you sign the sign in and sign out sheet both times in order to get your CLE credit. Finally, this is a hybrid presentation. I don't make many guarantees in life, but I can guarantee you that at some point there will be a technical issue. So when that arises, please bear with us, okay? We're going to do our best to get through that. And now, with that said, I'll hand it over to Ryan.
Well, good afternoon, everyone, and thank you for being here. When I found out I was able to come here in person to Dayton to participate in this program, right after learning that there was going to be an intense heat wave in the DC area, I was super excited. Imagine my surprise when I arrived here in Dayton to discover that the heat wave followed me here, apparently. But we're very fortunate to be in this beautiful building here, the University of Dayton School of Law. And to those who are joining us virtually, I hope you're somewhere cool and comfortable on this extremely hot day. I'm going to talk about some strategic and tactical considerations for a variety of different types of companies that might be considering bid protests. I'm also going to talk a little bit later about some things that you should think about, some particular red flags and other key priorities when you're entering into negotiations with other companies to do business with the federal government. But let me start by talking briefly about the federal acquisition regulations. Now, I know there is a broad spectrum of expertise here in the room in person as well as in the virtual attendance. So with apologies to those who have a lot of familiarity with the FAR, as we call it, I think it's important to set the stage and to understand what the FAR is and why it governs so much of the decision-making we make both strategically and tactically when we're talking about litigation issues in the realm of government contracting. And so let me just talk a little bit about the history of the FAR. It is an outgrowth of an older sort of precursor system of regulations called the Armed Services Procurement Regulation. And in the 1980s, it evolved into the FAR as the primary set of regulations used pretty much by all executive agencies in the United States at the federal level. And the purpose of the FAR, the policy reason behind the FAR really, is that the federal government is responsible for the taxpayer dollars that are used to buy goods and services, and it has to be a responsible steward of that public fisc. And so there are lots of rules and regulations in place to make sure that when the federal government is purchasing, it is doing so in a fair, transparent, open way, in a way that a government entity different from a private sector customer should be held accountable for. Let me also say, this is my personal sort of philosophical view about the FAR. Many of you will nod your heads along when you hear this, but my view is that federal procurement has really been an opportunity for social and economic policy experimentation by the federal executive branch. If you want, for example, to raise the minimum wage in the United States at the federal level, you've got to pass that through Congress. We all know how hard it is to pass anything through Congress at the federal level. But if you are the president, or if you are a cabinet level or other agency head, or you have the authority to develop a regulation that says anybody who wants to do business with the federal government from a procurement perspective has to pay the following minimum wage to their employees. You can get away with that because it is not a law that applies to everyone broadly across the United States. It is simply the cost of doing business. You don't have a constitutional right to do business with the government. So if you want to be let in the door to negotiate or to bid on a contract to do work, to provide goods or services with the federal government, these are the rules they set out in that procurement process. And so it has been used over the years as an opportunity to impose all kinds of requirements on federal contractors through the FAR, through the FAR, ranging from employment law to trade regulations to international relations types requirements to discrimination laws, rules and regulations that may have preceded other discrimination laws that were ultimately passed by Congress, to a variety of other things as well. Whistleblower requirements and all kinds of things. The FAR is codified in Title 48 primarily, although there are some other provisions, primarily Title 48 of the Code of Federal Regulations. And it has 53 parts. And each of those parts is voluminous, and they change regularly. Because they are regulations and not laws, every new administration can come in and say, because of our social and economic policy priorities, we might want to tweak the FAR. And then, of course, there are some other sort of operational reasons to tweak the FAR as well, as technology develops, as other priorities change for federal agencies. Other ways that the regulations can change on occasion over time, the National Defense Authorization Act, that is a congressional statute that is a must-pass piece of legislation every year to fund our defense agencies. Members of Congress do occasionally slip in little bits of language in that voluminous piece of legislation to implement other FAR regulations as well. But primarily it's done through executive agency regulation updates. And that requires contractors, as well as their lawyers, to stay up to date on all these constant changes and make sure that we are advising either within our company or our clients, if we are outside counsel, to stay on top of all of these things. Occasionally, we do have a client who is not well-versed in the FAR who will come to us and say, hey, can you just give me a 15-minute quick overview of the 375 FAR provisions that are tacked on to the back of this contract I'm about to sign with a federal agency? And when you think about the compliance obligations and the risk profile of all these different regulations that come along, many of which have nothing to do with the core scope of work of what your company is doing for the agency, we certainly do not recommend that approach. The FAR gets updated largely through a procedural process through something called the FAR Council, which is a tripartite group comprised of representatives from the Department of Defense, the General Services Administration, and NASA. It's sort of just an interesting historical anomaly as to why those three agencies in particular make up the FAR Council. But when they implement updates to the FAR, it applies across all agencies pretty much, even though those are the three that are on the FAR Council. And it has to go through the regular regulatory process. They have to publish proposed rules, give the public an opportunity to comment on those rules, consider the comments, and so forth before they can finalize those regulations. But they are constantly making those changes. Last thing I want to mention here is that there are many agencies that have their own individual supplements to the FAR. Now, they cannot contradict the FAR if the FAR applies to them, but they can layer on top of it additional requirements. So for example, the Department of Defense has Defense FAR Supplement, DFARS. Air Force has its own supplement. EPA has its own supplement. So if you are a company and you are looking to do business with one of these agencies or to respond to a solicitation, make sure you are paying attention not only to the main FAR and its 53 parts and any provisions that may be incorporated either explicitly or implicitly into the contract that you are about to sign. Also make sure to consider whether there are FAR supplements specific to that agency that will apply to you as well. Oftentimes, the contract will contain explicit references to the clauses that are meant to apply to that particular contract. But every once in a while, there are clauses that are not mentioned explicitly that by law, by operation of law, as we say, are still applicable to the performance of a contract, even if they're not in your contract, just to make things more complicated. This to work. Oops. Bear with me, as Jamar said, technology. The primary acquisition method, again, to reflect the policy priorities of the government in its purchasing activity, is the sealed bidding. This is competitive bidding, as many of you are familiar with. The government must engage in competitive sealed bidding as the sort of default position if certain standard conditions are met, as you see on the slide here. But there are certain circumstances under which the government can issue a sole source award. Just go directly to a company and say, you are getting an award from us because you have special expertise in a particular field, in a particular type of service that we need. Or through the 8A program, which is a special set-aside program for disadvantaged businesses designed to help them grow. So there are some exceptions to this, and there are some processes by which the government can sole source awards. It usually is required to issue a justification statement explaining from the contracting officer or from the agency why they need to sole source to a particular company that has particular expertise. Oftentimes in the defense arena, when you need a particular type of software or hardware, for example, that does come up. But otherwise, we have this competitive bidding process, which is why we have the bid protest process that we're going to talk about in a minute. I want to direct your attention to this column on the right-hand side of this slide, because more and more we're starting to see federal agencies use alternative contract vehicles to engage services and goods from contractors in various industries. Many of you may be familiar with the IDIQ, which stands for indefinite delivery, indefinite quantity. As a comparison, this is sort of like a master services agreement. It does not entitle you, even if you are a winner of this award, to any actual money for services, usually. Usually, it's just a ticket to the dance. And often it is a multiple awardee contract, meaning if 100 companies apply for an IDIQ opportunity, the government evaluates their bids and announces it's going to give awards to the top, let's say, 20 of those 100. And those 20 are now in, quote unquote, the IDIQ contract award, meaning they've been let into the dance, but there's no guarantee that anyone's going to actually ask them to two-step. So from that point forward, there's usually a purchase order or delivery order or task order process built into the IDIQ, which is sort of like a subcontracting process, not subcontracting, but subcontracting process, where once you're in the door, now you're competing with the 20 other awardees to try and get some of the business through a task order. Task orders are not always considered contracts themselves. Sometimes they are, sometimes they aren't. It may depend on the terms, it may depend on the value of the task order in terms of how much money it's worth. You could get a task order worth many millions of dollars underneath an IDIQ. And that will impact whether or not you can protest the award of a task order. Because if a task order is not considered a contract and the bid protest process is really reserved only for contracts, then you can have some procedural and legal challenges to how do you protest, how do you challenge the award of a task order to maybe one of those 19 other competitors of yours within the IDIQ framework, right? And then there's this new thing that's been talked about a lot in legal circles and government contracting, and we're still trying to figure out exactly how to treat it. It's called OTA, Other Transacting Authority, or Other Transaction Authority. And the concept behind OTA is that the government can do business, can secure goods and services without what's considered legally to be a contract. It's buying things in a different way. This is a hard concept to wrap your brain around a little bit, because if you're buying something, you think there's implicitly always going to be a contract. We give you money, you give us goods or services. But the government's view is this OTA is not a contract because of the way that they go about securing goods and services underneath it. And then it raises the question, well, how do you protest it if it's not a contract? So more to come on that as the law develops in that area, but it's something to keep in mind. Somebody I know, as you all were coming in, mentioned that they were a grants administrator. Grants are considered an entirely separate animal from contracts as well under federal law, and usually the FAR requirements do not apply to grants. And there are different rules set up for grants, but there are always exceptions. If a grant does explicitly incorporate certain FAR provisions, they sort of become part of the grant terms. That can happen from time to time as well. Okay, other methods of procurement include negotiation, which can happen even during competitive bidding processes, depending on how the RFP, the request for proposal, other solicitation vehicle is set up and what its terms state. The bottom line is that the contracting officer within the agency who is in charge of this procurement has enormous discretion and authority. As long as they abide by the rules of whatever FAR requirements apply, whatever evaluation criteria apply, they tend to have enormous discretion to do what they think is best for securing the goods and services that the solicitation calls for. We talked about requests for proposal. Bid deadlines are strictly enforced. Some of you may have dealt with this in the past, where you're putting together some massive proposal or bid for a complex contracting opportunity, and you've got a huge team and everybody's working on different parts of it. Somebody over here is working on the pricing piece, somebody over here is working on the technical piece, somebody over here is working on the compliance piece, and you're scrambling to get it all done and make sure that it meets all the requirements of a complex solicitation and gets in on time. And the horror stories are when, you know, the delivery person, the third party carrier, doesn't make it in time or gets lost, and it's 1 minute late past the 5 p.m. deadline on the day that the bids are due. It is extremely, extremely rare to win that kind of a protest. So make sure you get your stuff in on time with room to spare. We did many years ago represent a contractor who bid on a $100 million contract for IT services with the Naval Sea Systems Command. The Navy had set up an online portal for bidders to submit their bids through, with lots of attachments and other information. And in that rare instance, we were able to argue that because the portal was controlled and created by the Navy themselves, and because through a detailed forensic analysis, we could show that our client had in fact submitted all the materials and tried to upload them at 4:59 p.m., even though it took time for those materials, which were voluminous and had many megabytes, to fly through cyberspace and arrive in the email inbox of the contracting officer at the Navy, and he received them at 5:01 p.m., that they were in fact submitted prior to the deadline. But that is an extremely difficult argument to win. So please make sure you pay attention to those deadlines and don't take chances. It used to be that the standard for evaluating bids for many contracts was lowest price technically acceptable, which just means the solicitation would come out and it would say, this is what we need you to do, or what product we need you to provide. Here are all the specs. And whoever is able to provide that at the lowest price, that's who we're going with. It certainly triggers a lot of old jokes about government spending and purchasing. But more common today, after realizing that there are problems with lowest price technically acceptable, is the model called best value, which is a little bit more of a sliding scale. It's a little mushier, a little more touchy-feely. And again, it gives the contracting officer's team and the evaluators more discretion and leeway to determine, all right, maybe this contractor's bid is a little bit more expensive, but we're getting more guarantees of quality, or we're getting more value for the dollar, and so we have the authority to go with that bidder instead of one of the competitors who might have a lower price. There are also something called simplified acquisition procedures, where if you're buying something at a very low level, it's not that expensive, it's a small purchase, you can avoid some of the more onerous requirements of the FAR. Finally, this last little sub-bullet point, the Small Business Administration has very complex regulations governing set-aside awards to minority-owned businesses, woman-owned businesses, veteran-owned businesses, and a number of other categories that the federal government has, for policy reasons, identified as historically disadvantaged groups that we want to try and give more opportunity to participate in the federal procurement process. I could speak for many, many hours about the regulations governing those businesses and what the protests look like, because people can protest whether one of their competitors truly is minority-owned or woman-owned, or whether they only look like that on paper, or whether they are truly small, for example, depending on how much business they've done in the last few years and how much money they've actually taken in as revenue. So there's a whole separate set of procedures and a whole separate set of administrative tribunals and litigation processes on those types of issues, which are for another day. All right, so let's get to bid protests. Bid protest is nothing more than a written objection to the process of awarding or terminating a contract. And so it is really a form of litigation. It's a fast-track form of litigation. It has some different rules. It has some different standards. But at the end of the day, it's basically a lawsuit, okay? You're basically saying to the government, hey, we think you didn't apply the standards that are supposed to be applied the way they're supposed to be applied. You didn't apply them equally and fairly. You violated certain regulations that required you to do certain things. You counted certain technical capabilities of one of our competitors higher than you should have counted in the scoring system as you were evaluating all the bids. And you gave the award to the wrong company. We should have won it. That's really what a bid protest is. An interested party is an actual or prospective offeror, bidder, whose direct economic interest would be affected by the award of a contract or by the failure to award a contract. That's a quote defining the term interested party from the FAR. The reason I bring this up is because if 100 companies bid on a contract and they rank you all, and based on pricing and technical capabilities and experience, they rank your company number 99 out of 100, and they're going to award the contract to the top 10 scored companies, are you an interested party? Because even if you protest, if you don't have a good argument that's going to land you ultimately in the top 10 when they recalculate those evaluations, you're not really quite an interested party as company number 11 is on that list, right? Because they might get bumped up if somebody's disqualified in the 1 through 10 awards. So this comes up sometimes when we're talking about whether you have standing to bring a protest, something to keep in mind. There's something called a pre-award bid protest as well. And what this is a challenge to the solicitation itself. This is different than challenging the award, okay? If you want to challenge the solicitation itself, if your bid team is coming together and you're preparing your proposal and you're reviewing the pages and pages of requirements that some agency has put out and try to figure out, how to put your package together to comply with all of these requirements, and you come across a line in that solicitation, maybe it's an RFP, could also be an RFQ, a request for quote, and you see something that doesn't make sense, something that's technically contradictory, you might want to protest, not the awards haven't happened yet. You may want to protest the solicitation itself. In order to do that, you have to file your bid protest before the deadline to submit your bids. So if you file a protest and it turns out what you're really saying is you're challenging the solicitation, you're not challenging the award, but you don't file that protest until after all the bids have been submitted, you're too late. your protest is going to be dismissed because you're really challenging the terms of the solicitation that the government put out. So bear that in mind as well. And then a post-award bid protest, of course, challenges an award of a contract to one or more offerors to the exclusion of other offerors or bidders, basically making an argument that it's somehow flawed or unfair. Protests can be filed generally in 3 places. They can either be filed with the contracting agency itself or with the Government Accountability Office, which is an independent agency that falls under Congress's authority, actually, not the executive branch, and has its own little sort of mini court system. Or they can be filed with a special federal court in Washington, D.C. called the U.S. Court of Federal Claims. So the question is, should you file a bid protest? If you're in a situation like this, you do all the hard work, you submit a bid, and you lose. Well, it's got a couple of different things for you to consider there, right? There are the legal considerations as to whether or not you actually meet the procedural requirements. Is there still time to protest? And then what are your legal arguments going to be? Do you have a good faith basis to assert some claim that the awardee didn't meet a requirement? And then the question becomes, which forum is right for you? And before we go on to which forum is right for you, I should also mention there is, I think, a misconception in protesting that you're almost always likely to lose a bid protest. We talked a lot about the discretion of the contracting officer and the discretion of the federal government generally when it comes to its authority to procure goods and services. However, while in the world of general civil litigation, a plaintiff is generally more likely than not to lose a lawsuit when they bring it. It's more rare that a plaintiff will actually win a case. In the world of federal government contracting, it turns out when you look at the data, particularly for protests filed with the GAO, the General Accountability Office, Government Accountability Office, they've changed names but kept their acronym over the years. It turns out that the win-loss ratio is about 50-50, which is strikingly high. It means that if you're a protester and you submit something to the GAO, you might have a 50% chance of getting some sort of positive outcome. It doesn't necessarily mean you're going to get a slam dunk win, but you might get some sort of positive outcome that helps you and your company. So let's start with agency protests. Agency protests basically go directly to the agency. If, for example, you have a contract that you're bidding on with the Veterans Administration, the VA, okay, to provide some kind of services to them. You do not win the contract and you want to submit a protest. You would submit it directly to the contracting officer at the VA. Now, there are pros and cons to this option, and so you really have to think about the strategy and tactics here. The pros, of course, are that this is the agency you deal with. If you can approach it in a diplomatic way, maybe they'll be more open to your argument than some nameless, faceless, independent agency. The process, the procedure is actually a lot more informal generally when you're filing a protest with an agency as opposed to the courts. And they generally have to turn around your request pretty quickly to resolve protests, make their best efforts to resolve protests within 35 days of your filing. It doesn't mean that they will, but they should make their best efforts to resolve them within 35 days. But there are some inherent challenges involved in choosing the agency itself as the forum for your protest. First and foremost, there's a bit of a conflict of interest baked in there, right? This is the same agency, the same contracting officer's team who evaluated your bid and told you it wasn't good enough, right? And gave the award to somebody else. Oftentimes they spent many months doing a lot of work to evaluate the different bids to reach this conclusion. And here you come along telling them they screwed it up. Hey, you screwed it up. I think you should give that award to me instead of the other guy. There's a sort of a sense that even though they are objective professionals, we're all human beings here, and you're basically coming to the person who made a different decision and telling them that they messed up. And do you want to be doing that? The way that the agencies deal with that in the regulations is that the protester is entitled to ask for a review by somebody at a higher level within the agency who in theory should be more objective and more removed from the process of evaluating the bidders. So you request that your protest be reviewed by somebody above the contracting officer who awarded the contract to one of your competitors. In theory, that should help with the conflict of interest. In reality, a lot of these folks work pretty closely together. I don't know, if that's always the best choice for where you want to file your protest. There's also the business consideration, not a legal consideration, but if you are a company that does a lot of business with the Veterans Administration and may encounter the same contract administration folks and program management folks over and over again, if you do a lot of repeat business, maybe you don't want to annoy them or anger them by filing your protest directly with them. You could make the argument that filing the protest anywhere might annoy or anger them, but it becomes a little bit farther removed from those folks if you file it at the GAO or the Court of Federal Claims, when the lawyers for the agency have to really step in and do more of the heavy lifting. And I should mention that agency protests and GAO protests can be appealed, but that process usually goes to the Court of Federal Claims as well. GAO protests are often the go-to because they're a happy medium between an agency protest and a full-blown federal court litigation process where you have to go through multiple preliminary filings and motions, and you have to follow a lot of complicated rules with the federal court. The GAO is pretty streamlined, cheap, quick. They are, as I mentioned, an independent agency, and you have pretty decent odds of some kind of success. And success doesn't necessarily mean, again, that you're going to win everything you asked for. It might mean that they decide that the agency decides after looking into your protest grounds that maybe we don't agree with you, maybe we don't concede that you're right, but maybe you do have a strong legal argument and there's a chance we'll lose. So we'll voluntarily take some corrective action, reevaluate the bidders, or maybe even restart the entire solicitation process all over again, which in our world is considered a win for our client. Now, it doesn't necessarily mean that the client is still going to ultimately get the contract at the end of the day, because once reevaluated under the parameters that we demanded that they reevaluate under, our client might still lose the contract. Or in some cases, the corrective action is to simply walk away from the procurement altogether and have the agency decide, hey, we don't really want to do this anymore. We're going to just sort of scrap the program. And then your client, of course, is losing the opportunity to win that contract in the long run, even though in the short term, the corrective action was a quote unquote legal win. GAO protests have a very strict deadline to file, a very strict deadline to file. It is within 10 calendar days of notice that you did not win the contract. That is a very short turnaround for you and your lawyers to work on putting together what are the bases, what are the grounds legally and factually for us to protest, and then putting together the actual protest document itself. It can be done, it's done all the time, but it creates quite a scramble. So if you're thinking about protesting something that comes in that doesn't smell right, don't wait until day number 9 to call your legal team or think about filing a protest. There is an exception where under certain contracts, you are entitled by regulation, by law, to get a debrief from the agency. That means that the agency will, either through a phone call or through a Zoom or an email, give you some information about the reason why they didn't select you as a winner. And if you are entitled by law to get that debrief, you have to request it usually within 3 days of getting notice that you didn't win. And then when they get around to giving you the debrief, which may be weeks or months later, from that point, after the debrief, you might have some good information at that point to help justify the factual legal basis for your protest. You'll have 5 days to file with the GAO. The agency is then required to look at your protest, look at the grounds for protest, and within 30 days, file a report, which is essentially a response to the GAO to review and consider what their position is, and then you get another opportunity to respond. The companies that actually won the original award are also entitled to intervene in the case and defend their award. Now, protective orders are really important here because A lot of the bases for protests involve proprietary pricing information from your company, proprietary technical information from your company, which you don't want your competitors to see, and they don't want you to see theirs. So it is regular practice to impose protective orders where only the outside lawyers or other limited representatives of the companies that are involved in the protest litigation are able to see that information. It's attorney's eyes only, and it's very strictly enforced, but it allows the attorneys at least to see maybe there's another reason we can add to our list of reasons why the awards were made incorrectly, and then they can make those arguments without revealing sensitive information to their own clients. And then GAO has to make decisions within 100 days of the filing of the protest, so it's very efficient. And then finally, I'll just mention is the Court of Federal Claims. The one really big benefit to the filing in the Court of Federal Claims is they do not have the strictest deadline. I don't have a good slide for this. I'm just telling you about the Court of Federal Claims because I want to mention it. Usually, the deadline to file a protest with the Court of Federal Claims is 1 year from notice of award to somebody else. So it gives you a lot more time to file your protest. But do you really want to wait a full year to file your protest? Because by then, the companies that got the award are probably already performing and getting paid for their work, and it makes it a lot harder for you to kind of get any real relief that matters. Agency and GAO protests do not require formal pleadings, but there are some basic minimum requirements that you should put into any initial protest document, which are listed here. You can also sometimes get costs and attorney's fees if you are successful in your protest. It's not a guarantee. Sometimes it's at the discretion of the official at GAO who's reviewing your protest, but it does happen. And you want to make sure to be asking for the right kind of equitable relief. That means you want, at the outset of your protest, to ask for a stay of performance of the contract, because you don't want the competitor who won the award to go and start performing, if it's a construction contract, and start building something for the federal government, or if it's some other kind of contract, they start doing the work, and you come along and you protest, but you don't tell them to stop doing the work, right? Now, that kind of an injunction can be denied if the kind of work involved in the contract is critical national security or other type of urgent work that needs to be done and that the government can't really put on hold. But most of the time, the government will put it on hold while your protest is pending. Let's talk just for a few minutes. I know I have a few minutes left, but I want to talk about best practices for avoiding disputes with partners. So this is how do you avoid or preempt the problems from arising in the first place that ultimately will result in nasty litigation, not between you and the government, but often between you and a prime contractor if you're a sub, or you and your subcontractor if you're a prime, or other parties involved in performing. You need to have strong written agreements. I can't tell you how many times we've had clients come to us who made an agreement as a prime with their sub on a handshake. It's just should not ever be done. Or they used some form contract they pulled off the internet, didn't really read it, and now they're stuck with whatever the terms are of that contract. All parties really need to be careful of the terms of their contract. There's different kinds of contracts that you're dealing with in government contracting work, right? You're dealing with teaming agreements where companies get together and decide, hey, we're going to work together to bid on and try to win work. And the teaming agreement may have certain provisions in it that govern the relationship between you. There's subcontracts. After you win an award as a prime contractor, you have to enter into a new type of agreement with your subcontractor. Even if they were a teaming agreement member of yours, you still need a new subcontract document once the actual award is given. And that will govern the relationship between you and your subcontractor. If you're going to pursue a joint venture, which more and more federal agencies have decided they like, because it brings together companies that have different complementary expertise. And sometimes if you're trying to qualify for one of those valuable set-aside contracts, maybe it's for an 8A company, but your company is an 8A, so you form a joint venture with some small 8A company. They own 51% of the joint venture, you own 49% of the joint venture, and the government considers that to be an 8A joint venture because they own 51% of it, and you are eligible to compete for that valuable contract. Those agreements also are required to follow a certain pretty tight script that's laid out in the FAR, and any additional terms and conditions that you're going to add to those, you really need to understand. If you are the 8A, you certainly need to understand so that you can't be taken advantage of by a large company that is supposed to be the minority member of that joint venture, right? By minority member, I mean 49% owner. And if you are the 49% owner, you want to make sure that you are protected as much as you can be, either in a teaming agreement or a joint venture agreement. Some things to look out for: explicit work share provisions. Okay, I have seen many teaming agreements that simply say, we'll work this out later. Or they say, we'll do 51% of the work, you do 49% of the work. And that's all they say. That's pretty vague. There could be a lot of room for argument and disagreement over what that means and how to make sure that you're complying with that when, let's say you're the small business in a joint venture and the larger business owns 49% and they're trying to muscle their way into doing more than 49% of the work, or vice versa. Non-disclosure provisions, you want them to be enforceable, you want them to be written very carefully. You are sharing proprietary information usually with your partners, subcontractors, teaming members, particularly when you're putting bids together. You want to make sure they are protecting your information that they see, and you are protecting their information, and that there are serious consequences and easily enforceable consequences, such as being able to immediately go and get an injunction from a court, for example, that the other side waives their right to object to such an injunction, things like that. Now, there's a lot going on right now in the law about non-compete agreements. Traditionally, in government contracting, a lot of these types of agreements have had a clause called a non-compete agreement, which says you can't compete with us in certain other work, we can't compete with you in certain other work, and that our employees, we might have special arrangements with our own employees, you'll have special arrangements with your employees, our employees can't go to work for you, your employees can't go to work for us. That is a moving target right now. The Federal Trade Commission has come out with a regulation basically saying almost all non-competes are unenforceable, including retroactively, ones that have already been entered into. That will probably, that will definitely be challenged in court, and we'll see whether or not it holds up. But it's something to bear in mind when you're developing these relationships with your business partners in government contracting. There are also some FAR provisions that protect employees and independent contractors who do critical work. If you lose a contract and I win the follow-on contract for that project, and there are a bunch of critical employees of yours who are doing the work for some federal agency under that contract, you're not allowed to prevent them from being hired away by me. Interesting, right? Termination clauses. This comes into play particularly in subcontracts, where you want to make sure that if your subcontractor is doing a poor job and you want to get rid of them, you have an easy, clear-cut, understandable set of rules as to how you're supposed to do that. It also comes into play a little bit with teaming agreements, because the typical teaming agreement really only covers one bid process. Two companies get together, we're going to bid on this opportunity. But I have seen teaming agreements that cover multi-year period of time and say, we're going to bid on lots of different opportunities over the course of the next 5 years, the course of the next 10 years. And so even if you do have a falling out with your partner, or you do win a contract and perform it, and you want to move on from that partner, you might not be able to if your teaming agreement covers the potential for multiple opportunities over years. That's something to look at in your teaming agreements. And then, of course, procedures for pre-litigation dispute resolution. Usually there is a requirement in these contracts that says, before we go to court, we're going to go through a process where executives at one company will have good faith negotiations with executives at another company, and we'll do some other sort of internal procedural things to see if we can resolve disputes before we all have to start spending an arm and a leg on lawyers in some kind of formal dispute resolution. Communication is key. Do not proceed on a handshake agreement. And remember that there are flow-down provisions, the FAR requirements that we talked about earlier. When you are in a subcontracting relationship, even if you are third, fourth, fifth, sixth tier down in the supply chain of a subcontracting relationship, many FAR provisions by law flow down to every entity that is in that supply chain. You may be the sixth company down supplying some widget that's being used to build a new jet. You're supplying it to this company, who's then putting it into some component and supplying it to that company, who's then putting it into a larger component, to that company all the way up to the prime contractor, and you may not even realize it, but you are subject to many, if not all, of the FAR provisions in that prime contract. So that's really something to keep an eye on if you are doing any sort of work for any company that ultimately is being used for a federal government customer. And it's worth doing a little bit of an informal or even a formal audit of your business to make sure you have a good sense as to whether you have any that type of service or goods supply chain going to the federal government. A couple of quick things. The Severin Doctrine is a legal doctrine that basically says if you want to protest or you want to submit some kind of dispute to the government customer, but you're a subcontractor, you don't have what we call privity of contract with the federal government, right? The federal government only contracted with the prime contractor. They did not contract with you. And so if you have a beef that you need to be resolved, usually in a prime contract subcontract arrangement, you will bake in language into that agreement that says, if I, the subcontractor, want to raise a concern and make it a formal claim, the prime contractor will agree to pass it along to the federal government on my behalf, because that's the only way it can be raised. That's what the Severin Doctrine says. But it says that can only be the case if the prime contractor has actually paid for that work by the subcontractor and then in turn hasn't been paid by the federal government for it, or if it will somehow otherwise be liable for the subcontractor's damages. There's also something called the Christian Doctrine from a case called Christian years ago, which I alluded to earlier when I said that even FAR clauses that are not explicitly referenced in a contract with the federal government could still apply to you as a prime contractor if the substance of that FAR clause is applicable in that situation. And that's what the Christian Doctrine says. It's kind of a scary thought that you're signing this contract, and even if it's got 100 FAR clauses cited in it, there may be 101st one that you are obliged to follow that you don't even know about if you're not familiar with the FAR clauses that apply in this situation. Teaming agreements have also become red flags for antitrust scrutiny by DOJ lately. Some particularly egregious teaming agreements that get companies in a particular industry together to say we're going to team and bid on things as they come up could potentially run afoul of certain antitrust laws. It's usually the big, large companies getting together to do that in a particular industry, but it's something to be aware of. And then finally, I just want to mention the limitations on subcontracting rule, which is something we come into contact with a lot, and then I will shut up, I promise. I know I've been going for a long time. This is a rule that basically says if you are going after and if you are going to win and perform a contract that is set aside for a small business, as that term is defined in the federal law, or a small business with other special characteristics that qualify it as a woman-owned small business or a veteran-owned small business, etc., you cannot, by law, subcontract more than 49% of the work to a subcontractor. You, the prime contractor, have to perform at least 51% of the value of the contract. A lot of people don't understand this or don't know it exists. It is a very important concept and a very important provision, and a lot of small companies get in trouble because they bid on these contracts thinking they're going to, they're just going to be a pass-through, or they're going to subcontract out 90–95% of the work, and you cannot do that. You cannot do that. The reason you cannot do that is because the policy at play here is to help build up the experience and the capabilities of that small company so that it can eventually be a big company. And if all you're doing is being a pass-through, that's a big no-no. So something to keep on your radar screen as well. So I know I covered a lot of ground. I appreciate everyone's patience, and I'm going to pass it back to Jamar to talk a little bit about managing claims under the Contract Disputes Act.
Okay, before we get started there, recognizing that there's broad spectrum of expertise and levels of experience here, does anyone have any questions for Ryan? Any virtual questions? Okay. The first tracking code is TH4367. 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 All right, so I'm going to talk a little bit about the Contract Disputes Act, claims under that act, and I'm going to lead into our conversation about responding to information requests, subpoenas, CIDs, and things like that. The Contract Disputes Act is the primary avenue to recover damages due to changes, delays, inefficiencies, and other government caused issues. It was enacted in 1978. It aims to encourage resolution of contract claims before you get to litigation. Underlying policy is to, again, avoid litigation. And when litigation cannot be, when you cannot avoid litigation, provides a framework for how litigation should occur. It's supposed to streamline litigation, make it quicker than filing suit in a normal court. It governs post-award monetary claims such as breach of contract, non-monetary claims where you're asking for, you and the government have a contract and you disagree on an interpretation of the contract or disagree on one of the requirements of the scope of work, or you have a claim that relates to or arises from an implied in fact contract with the government. It does not apply to torts, claims for fraud, and bid protests. So how does it work? So let's say you're a young or newer government contractor, you win that contract, you read that contract, and as Ryan said, you understand, or you think you understand everything you're supposed to do under that contract, and you know your scope of work. You start work on that contract, but then something happens. Contracting officer says, well, you're supposed to do ABC, but I'm going to give you this order that says you're supposed to do XYZ. Or in performing ABC, you realize, I need to do other stuff in order to carry out the mission of performing ABC. Those things that constitute significant changes, significant modifications to your work are kind of what drive disputes under the Contract Disputes Act. So changes can be constructive or they can be actual or constructive. An actual change is, again, something where the contracting officer issues a written order and says, hey, we're making this change to your scope of work. Constructive change is something that you notice or that is discovered while you're performing the work. It's not necessarily something that's written. It's not necessarily an express instruction from a contracting officer. Generally, changes are only compensable if they're authorized before the fact by a contracting officer or ratified after the fact by a contracting officer, simply because your day-to-day experience might be with the Corps or might be with the contracting officer's representative or some other official. Just because they give you an instruction does not mean that that instruction is going to be, that instruction for a change does not mean that that instruction is going to be something that the government will necessarily be liable for. So changes, to the extent they're going to be compensable, have to be authorized by a contracting officer or ratified by the contracting officer. To preserve a claim under the Contract Disputes Act, the best practice here is to put it in writing immediately, send it to the contracting officer. So if there's a written change, you have 30 days to notify the contracting officer of that written change. If there's a constructive change, you have 20 days to notify that contracting officer of the change. So the best practice here is not to wait to day 19, not to wait to day 29, obviously. You're smiling. Yeah, you don't want to wait till the last minute, right? You want to put it in writing early and often. There are rules where in some situations these notice requirements might be waived, but you don't want to depend on that early, right? The best practice is early and often. And also, you should, if you're a government contractor, you should be in regular communication with your agency, right? Your agency should know what's going on. You should know. Yeah, you should be in communication with your agency. And whether your point person is the contracting officer or someone else, they should know what's going on. So this really shouldn't be a surprise when you're issuing that notification. If after the notification of the change, you can't reach a resolution, the next step is a request for an equitable adjustment. An equitable adjustment should spell out what the change was, how it impacted your performance on the contract. If it has caused a delay or it's going to extend the time to perform the contract, that should be in there. If it's going to impact other terms of the contract or your scope of work, that should be in the request for equitable adjustment. One of the things you don't want to do in the request for equitable adjustment is ask for a final decision or anything that comes close to the line of a final decision, because that's something else we're going to talk about in 2 minutes. Okay. Ryan mentioned this earlier. It's important to know what your contract says as far as dispute resolution procedures. If there's something in there that you should follow before you walk down the path of submitting a claim, you should know about that. And if the request for equitable adjustment is denied or you can't get it resolved, the next step is submission of a formal claim. Submission of a formal claim is kind of the big step here, is when you're saying, hey, government, this is an issue. This is something that we really feel serious about. And that's the point where it becomes a little more contentious. That's the point where the lawyers start to get involved. Okay. A claim is a written request to a contracting officer. Written request to a contracting officer for relief before a decision seeking a sum certain, an adjustment or interpretation of contract terms, or other relief arising under the contract. So if your change required you to expend more money, or if you're going to incur more costs, so you're going to seek money under this claim, you must provide a sum certain. This is not like a negotiation situation where you send a letter to the contractor saying, well, I think we can maybe make a case for $700,000, but I think your claim is really $500,000. It must be something stated in good faith. It must, you must have a reasonable basis for the sum certain you're stating in the claim. Okay. Supporting documentation not required when you're submitting a claim to the contracting officer, but it is obviously the best practice, right? The contracting or the claims I've worked on, we've spent tons of documentation, all of the emails that we think are important, all of the communications with the contracting officer or with the core. We will attach modifications, contracts, all the things that we think are important. If your claim is for over $100,000, it must be certified under the penalty of perjury. Okay, so typically the way ours look is we will submit a letter to the contracting officer signed by counsel, and if the claim is over $100,000, we'll have the company sign a separate certification that we attach to the claim. If the claim is over $100,000 within 60 days, the contracting officer must do one of the following: either issue a final decision or inform the contractor of the date when the final decision will be issued. If it's less than $100,000, contracting officer must just issue a final decision within a reasonable time. What's reasonable depends on the facts, depends on what you're asking for, depends on how much documentation you're submitting. There's really kind of no hard and fast rule. You guys have a lot of experience. So you're getting a lot. So if you have any questions, feel free to jump in. The best practice is submit your claim directly to the contracting officer. You can submit your claim to other representatives of the government, but you don't want to be in a situation where you're depending on somebody else to forward your claim to the contracting officer. That's just not something you like to do. And the last one we worked on, it looks like letter. We sent it directly to the contracting officer via email. They confirm receipt. It just avoids a lot of headaches when you submit it directly to the contracting officer versus your day-to-day or another representative of the agency. The contents of the claim. There's no particular format required for a claim. In our practice, it typically looks like a letter, again, signed by counsel. When a certification is required, we attach the certification to the letter. The claim should provide the grounds, the legal basis for the claim, and explain the nexus between the purported change and the relief you're requesting. A best practice is to explicitly request a contracting officer's final decision in your claim. And in our last one that I worked on, we literally had a section that said request for final decision to make it clear to let the contracting officer know this is what we are asking for. That's one of the check marks you have to hit in order for it to qualify legally as a claim. Contractor may pursue settlement or mediation. Generally, there's conversations here, and at any point in time that the contractor and the government can agree to a settlement. But to recap this, particularly for the people that are newer to government procurement, your claim must be in writing. It must provide factual and legal grounds for the relief requested. Any sum of money you're asking for must be a sum certain, must be asserted in good faith. If it's over $100,000, has to be a certification attached to it, certification under penalty of perjury, and it has to be submitted within 6 years of what gave rise to the claim. Okay, there is a 6-year statute of limitations. If the final decision issued by the contracting officer is not to the government contractor's liking, they have appellate rights. They can appeal to the Court of Federal Claims. They can appeal to the Regulatory Board of Contract Appeals, whether that's the Armed Services Board of Contract Appeals or the Civilian Board of Contract Appeals. If you're appealing to one of the boards of contract appeals, you have 90 days from the contracting officer's final decision. If you're appealing to COF-C, you have a year from the contracting officer's final decision, and these filing times are jurisdictional. So if you don't meet these filing deadlines, you're done. There's no claim. Okay. If you're unsatisfied with your claim, or if you're unsatisfied with the outcome of your claim before the board or before COF-C, you can appeal to the Federal Circuit Court of Appeals. And once you reach this level, once you start the appeal process, whether it's to one of the boards or whether it's to the Federal Circuit Court of Appeals, it looks a lot like general litigation, right? It looks like a lot like federal litigation in court. It could be just as contentious, it could be just as costly, but that's just something to look at. You're going to have pleadings, you're going to have discovery, you're going to have hearings, you're going to have motion practice. Are there any questions before we move on to the next section? Okay. So Ben and I are going to talk to you a little bit about information requests, particularly the common types of information requests that government contractors see. And those range from informal information requests all the way up to search warrants. Informal requests are obviously kind of the least compulsive. Search warrants aren't really requests. The government's saying, we're coming here, we're looking through your stuff and we're taking it. You don't really have, it's very compulsive. It's obviously not voluntary at all. I'm going to skip this slide in the interest of time. Some of the major ones we see are civil subpoenas, right? A civil subpoena is essentially a request issued by a party in private litigation. Typically, these are private parties that are suing each other that say, hey, you are a government contractor, you assisted in work or you have information that we think might be valuable to this case. So we're going to issue you a subpoena. A lot of times our clients get a civil subpoena and they think, well, I haven't done anything wrong. This is pretty innocuous. And this is for a civil case. I'm just going to give you all of the documents you are requesting. That is not the way to do this, okay? I see laughs in the room, but that has happened several times, and it is not the way to respond to subpoenas, okay? The best thing to do is to get counsel involved. Because even for civil subpoenas, which again may seem innocuous, you don't know if by producing certain information, you're running afoul of non-disclosure agreements. You don't know if by producing information, you're running afoul of certain regulations that require the information to be protected. The counsel can help you get a protective order to make sure that certain information is protected, even if you ultimately have to turn it over. Counsel can help you object to a subpoena if the subpoena is overly broad or unduly burdensome, or it's going to cost the company a lot more money to respond than the company anticipates. Administrative subpoenas are subpoenas that are generally served by government agencies. There doesn't have to be a pending litigation like a civil subpoena. Most federal agencies have pretty broad authority to issue administrative subpoenas. And while they're a little more compulsive than a civil litigation, there are objections that can be raised to administrative litigations. One of the important things to remember, again, you get an administrative subpoena, probably being investigated for something. So it is important to get counsel involved. You don't just want to respond to an administrative subpoena, even though you say, well, it's not a grand jury subpoena. It's not, we're not a target of some crime, or we're not a target of a criminal investigation. You're being investigated for something. So you want to get counsel involved. And are there any questions about civil subpoenas or administrative subpoenas? I know I was talking kind of fast, but we had to get through a few slides. Ben, are you ready?
Sure. Thank you. Good afternoon, everybody. My name is Ben Sandlin. Like Jamar said, I litigate mostly, so when I meet people, I apologize for meeting them first, because normally when you see me, you don't actually want to see me. It's good to see a room full of people who actually want to see me today. I am going to talk to you about the rest of investigative demands and the ways that government gets information. A civil investigative demand, we call it a CID. It's one of the best ways the government can investigate alleged or suspected violations of the False Claims Act, which is the government's favorite tool to determine whether a government contractor is making false claims. The government can then recoup some money from, punish you civilly, potentially criminally. They can seek documents, they can seek depositions and testimony. These can go on for a while. So it's important, like Jamar said, to get a lawyer involved very early to attempt to narrow the scope if that's applicable, help you manage the response, help you understand what they're investigating. You might get a CID and not really know what's going on or what's being investigated. Sometimes the lawyer can help you with that. It's a very low bar to serve a CID. While Jamar is correct that there's probably something going on that the government's investigating, it's not iron tight or airclad by any means. It's not, you know, that you're gonna absolutely get sued by the federal government, but if something goes south, it might happen. So this is your first clue that something is amiss. A grand jury subpoena is a step up, okay? A grand jury subpoena originates from a grand jury, a prosecutor issues it. It tells you in big, bold face that a criminal investigation is happening and you are somehow related to it. You could be just a witness, which is when you see something and you know, oh, I saw so-and-so there doing that, and they want your documents. You could be a subject, which is a little bit higher than a witness. Not great to be a subject, but maybe the government is looking at something specific and they think, hey, you are a subject to that. Let's see what's going on in that government contractor's business. If you're a target, that means you are the target of a criminal investigation. That is when we go, hang on a second, batten down the hatches. We're going to have to talk to these prosecutors pretty aggressively, understand what's going on, and try to make sure we navigate you away from being indicted. That is what we want to avoid. So that sounds very scary. When you engage counsel, we can help you walk through that process, make it a little less scary for you, but understand that the grand jury subpoena is just below the search warrant, kind of the most serious level of investigative demand by the government. I do want to highlight that these are federal and state level. You can get an Ohio grand jury subpoena or a federal grand jury subpoena. They both carry the same amount of significance to me when I receive them, because it tells me a grand jury has been convened, they're investigating a criminal matter, and this government contractor or client is somehow involved in that or has documents relating to that. I mentioned this already at the top, that there are different levels of folks in an investigation. It does not say on the face of a CID or a grand jury subpoena, you are a target, okay? That would be too easy. One of the things that we do is we talk with the prosecutors or the investigators and we find out, if they won't tell us explicitly, we do our best to find out based on the clues in our experience what is going on in your specific organization. And that way we can help you kind of manage the correct response. If you don't respond to a CID, you throw it in the trash, you don't look at it, if you don't respond to a grand jury subpoena, there are procedures that the government can take to force your response, to compel your response, and make sure you do respond. We can manage that for you. We can manage the deadlines, we can manage the communications. It's very important to maintain open communications during this process so no one, you know, gets scared about what's happening behind the curtain. And finally, if let's say you're just a subject, everything's fine, you have documents, but you don't do a good job at responding, they think you're hiding something. Worst case scenario, you certify it's complete under oath when in fact it's not a complete response. That itself could be criminal. So there are a lot of pitfalls in responding to these. That's why we're here, to help you walk through it and make sure that when you say your response is complete, it is complete. If they want to talk to you further, we can prep you for that conversation and say, these are the dangers in what we're seeing in the documents. Let's figure out a way to talk about that when the investigators ask you about it, okay? So that's why it's incredibly important to retain counsel in response to these. Steps to responding to an information request. These are basically step-by-step. You'll notice the first step is call a lawyer. That is a critical step. We can help you understand not just what comes next, maybe things that have happened previously that you've missed, and we can jump immediately in. Just because you call us doesn't mean it's going to cost you a bucket load of money. We can also look at it and say, you're going to be okay on this. We'll take a first cut of the documents. We'll help you manage it, but don't think you're going to spend an arm and a leg. There are other times where we'll say, look, this seems pretty serious, and so we need to get in there, and it's going to be an upfront cost, but we can manage that as well. So sometimes I get clients in that go, oh, I waited to call because I didn't want to spend a bunch of money. Your best bet is to call us earlier, so then we don't have to go back and fix some stuff or play catch up, because that's where the big spend happens. The second thing that we're going to do is we're going to read the whole demand, the whole grand jury subpoena. There are terms buried in there. They're very long about how the government wants the response to look. Every district, every United States Attorney's Office, and by that I mean like different one serves Cleveland and Cincinnati, want it different ways. And so our job is to make sure that we give them the documents in a way that they're asking for them to be produced. That's not really your job when you hire us. We're going to send you a litigation hole. And while you're not in active litigation at that point, that's a really good way, kind of belt and suspenders, to tell your employees and anybody else that has access to relevant information, hey, don't put this anywhere. Leave it where it is. Don't touch it. Don't delete it. Don't do anything like that. If they've already deleted something that's important, we can get in there. We can talk to them, potentially recover it. We use really good experts in that field that can recover that data sometimes, so we can save you from spoliation concerns or evidence destruction or tampering. Those are issues that you want to avoid, and we can help you navigate those. And then we'll take lead if it's important enough to the company. If the response requires it, we can even take lead in talking with your IT folks or your vendors to make sure that we're crafting a response that we would be comfortable with as certifying as complete to help satiate the investigator's request for information. Next, we're going to consider confidentiality concerns. Like Jamar and Ryan indicated, obviously there's confidential information floating around in your business that you don't want other people to find out. Something people don't think about is like FOIA requests. FOIA requests can sometimes get to this stuff. And so we can use the regulations to try to prohibit your competitors from acquiring any information from a FOIA request. There are other concerns. HIPAA concerns are a huge concern. Grand jury proceedings are usually secret, but we like to cover that with additional confidentiality requests. So there are things we can do to protect your information once it is in the possession of the government. And then finally, if we're going through this CID or grand jury response, we can talk with the investigators and say, look, we know it's not complete, but we've given you a lot. This is what we see the document saying. Are you okay with that? And if they let up on us, then we can say, okay, you're done. We can manage that negotiation and conversation with the government. If they release you from your obligation to produce, then that's a win at that point. After you receive, after the investigators receive information, it goes behind a little black box, and then they look at the documents and the information they've received. If it's a civil proceeding, filed action where you've received a civil subpoena, you can manage the docket. We can look at that. It's normally public dockets, and we can say, oh, they're moving along. They may not be after you. This is going to go away. There are some times, like I mentioned, grand jury proceedings are secret. We won't have a seat at that table, so we won't know what's going on. That's why it's important for us to build the relationship with the investigators at the front end for you, so we can maintain communications even after your production's complete. So let's say you were a target, we can say, hey, what's going on? Are you looking at this? What are you thinking? I had some prosecutors call me the other day in a matter and said, we don't really want to go after your guy. You've produced a lot. We've got a settlement offer. And we talked about that. So that person likely won't be facing a lawsuit by DOJ, potentially a settlement instead. So that's, again, wins are relative in my life. That's a win for me. When they make a decision about what they want to do, they'll either let us know, and then we can tell you the good news, or it could be that you get brought into a lawsuit. Again, worst case scenario is you're subject to a grand jury subpoena, or you're a target of a criminal investigation, or you suffer from a search warrant, and then you're indicted. In that case, you really want counsel before the indictment, because we want to be hands-on managing that kind of stuff, so we don't come in absolutely blind. Again, that is a worst case scenario, but it can happen. So now that I've scared you, I want to talk about how to not have any of that happen. Like I mentioned, I normally get clients when stuff like that's happened, but I am happiest when I get clients in this phase before anything bad happens, so they can safeguard against any kind of procurement fraud exposure.
I have a question.
Yes, ma'am, please.
You mentioned you can have both state and federal issuing subpoenas.
Yes.
When that happens, where both of them are doing that, do you presume that they're coordinating their efforts or no?
That's a great question. Do I presume that the state and the feds are coordinating? I try not to presume very much. If they're overlapping too much, it could go either way.
Tell the other one that you are getting.
Yes, that was what the point is. We want to be the center of communication for your company. So anything that the government's getting from your company is coming from one source, and we kind of hold all the documents and information so they don't get conflicting information. That's a huge pitfall. If you're facing a civil subpoena in an active case and then a grand jury subpoena with a federal United States Attorney's Office, you want to manage that response to make sure that the other one isn't left guessing about what's happening. That's a very good question.
On that note, I'll just say you can get subpoenas and information demands from various federal agencies as well. So sometimes they don't always coordinate. There's supposed to be a no piling on policy by DOJ, but they don't always talk to each other.
So the first thing I'm going to highlight is the False Claims Act. And like I mentioned, there's civil and criminal liability under the False Claims Act for making false claims to the government for payment. These are the elements, the liability for, and then the blue boxes. You'll see it's basically knowingly presenting a false or fraudulent claim for payment. What that looks like in the government contracting space is when Ryan's talking about the FAR provisions, and you're knowingly signing a document, knowing you're never going to meet that FAR provision. That's when you're opening yourself up to exposure. So something that's not even in the contract, like Ryan said, and then you sign the contract knowing you're never going to satisfy the unlisted FAR provision, could be a False Claims Act issue down the road. That's kind of the soup to nuts of what you're hearing today. False Claims Act is a federal statute, but there are state statutes as well. And the DOJ has collected a lot of money under the False Claims Act. I think in 2023, it was almost $2.7 billion. So it's a lot of money. It's nationwide. One of the most interesting portions of the DOJ's initiatives right now is their cyber fraud initiative. And I looked at this from DOJ's website. Promote cybersecurity compliance by government contractors and grantees by holding them accountable when they knowingly violate applicable cybersecurity requirements. Wow, when they knowingly violate those requirements. I mean, this is serious stuff. And it can go on in the background of your company, like this Jelly Bean Communications case. Very interesting case. DOJ recovered almost $300,000 from a company doing basically IT work in Florida because they got hacked. DOJ said, well, the fact you got hacked showed us you weren't cyber secure. And so we want $300,000, and they paid it. In the Aerojet Rocketdyne case, that was initiated by a whistleblower. We did kind of gloss over that. Whistleblowers are a very important aspect of this. This is the person who observes something that they think someone else needs to know about, and they raise their hand and say, hey, wait a second, something's not right here. And so at that point, they're subject to certain whistleblower protections. But whistleblowers inside of a company are very, very important to DOJ because they give them insight into the company about what's happening, maybe not publicly. In the Rocketdyne case, a whistleblower initiated this, and this company paid $9 million to DOJ for misrepresenting compliance with cybersecurity requirements. So there's a cybersecurity requirement in a contract that they signed, knowingly misrepresented it, and they're liable for $9 million. That's why it's incredibly important to make sure that everything in your contract is buttoned up tight. You know what's going on, you know what you're technologically capable of, what you're not capable of, and you get it right on the front end so you don't have to deal with someone like me on the back. I'm happy to deal with you all, but I get the sense you don't want to deal with me very much. These are your step-by-step safeguards, okay? First, you need a thorough compliance program. And I want to stress this is tailored to your business. If you don't do medical stuff, you don't need much HIPAA concern. If you have PII of your employees, certainly protect that, but you're not dealing with patient PII. That's very different than an IT company, for example. You need to conduct regular audits of critical systems, contractual requirements, and personnel. So there are certain systems in your company, you're probably thinking of some now, that are not mission critical to what you do. Every now and again deserves a checkup. But if you have a critical aspect of your company, like the revenue driving aspects of your company that are constantly subject to scrutiny by government contracts, you need to make sure that those are in compliance with what you're promising the government they can get out of your company. The way you do that is to conduct internal investigations. That's something that our firm offers. You could be subject to an information request or not, and we can go in and we can kind of audit your critical systems. We'll interview kind of your key employees to make sure they're doing everything right. We'll review your documents. We can do this completely covertly if you don't want your employees to know. We can do it overtly and come in the middle of the day and say, hey, we're just making sure everything's fine. It's completely up to you. And we can help you craft that to make sure that it's most appropriate for your business and the environment that you're trying to foster, while also addressing the problem or auditing the system that you're asking us to audit. Obviously, you need to closely read your contracts. That's something that Ryan and Jamar emphasized already, obviously. Make sure that you're agreeing to the correct FAR provisions, that you understand what the hidden FAR provisions are. And finally, you need to call a lawyer. Okay, I might have needed to put that first, but I started with that, maybe I'll end with that. You should certainly call a lawyer who specializes in this area of government contracts, internal investigations, criminal defense, especially federal defense. This is an area of law that not everybody does. And you may be getting a sense right now that there are a lot of traps and a lot of hidden stuff that goes on behind the scenes, and that is true. That's why you need someone who is knowledgeable about this area, who has experience in this area, to make sure that you are on the right track. So that's my bit. I came in really hot at the end. I'm sorry to scare you. It's just what I do every day. I really appreciate you guys listening. We definitely have some time for Q&A. I think I'll sit down to do that though, so I'm not the one in the hot seat. But please, if anybody has any questions, or if you have any questions on chat.
Not yet.
Okay.
Jamar, do you want to read a second?
Sure. While Jamar's going up, do you?